Okay, yes, I think let's get started. Okay, great. Yes, yeah, thanks everyone for being here. Today it's our great honor and pleasure to have Peter from Coin Center to give the guest lecture today. Peter is the Director of Research at Coin Center, and Coin Center has played a key role in crypto at the intersection of law and cryptocurrency. And Peter has spearheaded this whole effort. So today, Peter will talk about cryptocurrency and privacy law, Fourth Amendment, and non-delegation. With that, thanks a lot, Peter.
Great, thanks for having me. So for those of you who don't know Coin Center is an independent nonprofit research and advocacy organization that's based where I am right now, Washington, D.C. I mean, it's not based in my office, but it's based here. We do a lot of work from home now because of COVID. And our objectives since 2014, when we first started, have always been to educate people in government, primarily the US federal government, which is why we're in DC, but also at the state level and some degree in the international level, about how cryptocurrency technologies work, what good they can do in the world, what are their risks. So, we're not here just to boost the technology, we're here just to give honest answers to questions. And so, and the objective there is so that when governments are going to govern, when policymakers are going to make policy, generally speaking, we're always going to get better outcomes if they at least know how the technology works, rather than, trying to regulate Bitcoin like it's a bank or something like that, because it just wouldn't make any sense. And it would lead to a lot of collateral consequences. So as we've gone along, the mission has shifted from education focus to more of a focus on defending civil liberties, because at a foundational level, while we want policymakers to be able to reach their objectives, whether they're investor protection or anti-money laundering, we only want them to be able to have power to do things up until it starts to intrude upon constitutionally protected rights, like our right to publish software freely, or our right to some level of privacy, maybe a warrant requirement before our personal information is searched or seized by the US government. And so increasingly, we're brushing up against the government and looking at proposals from the US Department of Treasury or the SEC to regulate the technology in a way that actually intrudes upon our First Amendment and Fourth Amendment rights. So this presentation is an update as to the current state of sort of privacy and cryptocurrency policy at the US. And we'll talk about a few big things. We'll talk about the Mnuchin rulemaking that happened 2 years ago and hasn't finished, which was sometimes referred to as the unhosted wallet rulemaking, where if you were moving money from Coinbase to an unhosted or a wallet you hosted yourself, the Treasury uses the term unhosted, which is not helpful, you would need to tell Coinbase, or Coinbase would need to know the name and physical address and other details about the person you're paying, who controls that wallet, even though that person's not a customer of Coinbase. Second, we'll talk about the 6050I reporting requirement that was added for cryptocurrency transactions in the infrastructure bill last summer and how that affects privacy. And this has to do with sending transactions from one person to another, not through a financial institution, not through Coinbase, just cryptocurrency that I control, I send directly to you. Who has to report? Does anybody have to report? And finally, we'll talk about the Tornado Cash sanctions, which started just last August, and what those mean for privacy and whether they're legal, or whether they're being done in a sort of extra legal fashion that can be challenged. And the basis for a lot of the material in this presentation comes from two reports, which I'd recommend if you want a base of knowledge in this space. One is The Case for Electronic Cash. It was written by Jerry Brito, Coin Center's executive director. And it makes the moral and ethical case, defense, if you will, of why we really need peer-to-peer electronic cash, things like Bitcoin or Ethereum, but actually really ideally things like Zcash or Monero or Ethereum or Bitcoin with some level of increased privacy, because the public blockchain is a little bit too transparent, really, to protect human dignity and human freedom. And then the second report is Electronic Cash, Decentralized Exchange and the Constitution. And in that report, we get into sort of hypothetical government actions that would attempt to limit the amount of privacy that people can have when using these networks, especially as stronger, more private networks emerge. And what would be the response from, say, a civil libertarian minded challenger of those laws? And the response was going to be that, you know, you're transgressing the Constitution. You're either violating people's speech rights under the First Amendment, or you're violating their privacy rights under the Fourth Amendment. And we go through really in depth how you would construct those arguments and what is the underlying constitutional and statutory law at stake in that report. So the first report's more moral, ethical, sort of almost philosophical public policy arguments. And then the second report is more lawyerly constitutional law and statutory law of privacy and these new technologies. And they're both available on our website, coincenter.org. So the first thing I want to cover is, what is AML-CFT? Because this is this term that comes up all the time when policymakers talk about regulating this space. This abbreviation stands for anti-money laundering, counter-financing of terrorism. And it's kind of a euphemism because how could you be being against money laundering? That means you're pro money laundering, right? Or how could you be for financing of terrorism? You must be counter financing of terrorism. And so these are ways of framing the policy discussion here in a way that seems like you couldn't possibly impugn it. Like, what are you, a money launderer or a terrorist? And the thing is, that's not great, because what AML-CFT really is all about is warrantless surveillance. And I think it's quite reasonable to be against certain levels of surveillance or certain levels of warrantless surveillance, where some random person in the Department of Justice can get information from me without even needing to go before a judge and proving before a judge that they have a reasonable suspicion that I've committed a crime. And so it really is euphemistic to talk about this policy area as AML-CFT rather than warrantless surveillance. But that is the term AML-CFT that you'll see in most DC-based policy conversations. If you see that term, just remember, they're really talking about warrantless surveillance. And this might be controversial to some folks who've been working in compliance, in banking regulation, in DC generally. But I don't think it should be controversial, because the bottom line is that under the AML-CFT regime that we have, financial institutions are obligated to report some types of customer information without an investigator even having to ask for it. So your bank or Venmo or whoever you're using to do payments, if you're not doing them yourself with cash or with cryptocurrency, that third party is obligated under US law to file certain reports about your activities if they qualify. And those are currency transaction reports. So if you go and we withdraw more than $10,000 in cash, then there's going to be a report filed by the institution you withdrew from. If you have a transaction that you make that's over $2,000 and there's something suspicious about it, and the institution, the bank, is allowed to define what they think is suspicious or not, they have to file a report about it. So at no point does government ever go before a judge and say, we think Peter's being shady. Here's some evidence of his being shady. Please give us a warrant to collect his entire bank record history. This is not like that. This is just, the government doesn't even need to ask. The financial institution, Merrill Lynch, Bank of America, whoever, just decide, yeah, okay, we're just gonna share some information with the government now because Peter's being shady. And financial institutions have to collect all kinds of other customer information below the $2,000 transaction threshold, and keep that information available on their servers, such that if an investigator was to call them up and say, hey, I'm looking into Peter, can you give me some more info about them? They have that available. And again, that can also happen without a warrant. A prosecutor can just send a subpoena to Merrill Lynch or Bank of America or whoever and collect that information. They could even just do it over the phone. And it would be up to Bank of America as to whether they're going to stand up for the privacy rights of their customer. And I think I wouldn't be saying anything shocking to say that generally they don't. And so given that this regime exists and has become sort of the default for how we move money around the world these days. It's always through third parties, and it's always therefore subject to surveillance. We might ask, well, how does the Fourth Amendment still, a thing? It seems like the Fourth Amendment isn't doing much anymore, because the Fourth Amendment is our privacy rights in the US. It's more specifically a certain type of privacy against government searches, not necessarily against corporate surveillance or things like that. The Fourth Amendment says the right of the people to be secure in their persons, houses, papers, effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause. So the government should have to prove to a judge that they have cause to search your information, your private information, or your house or your person, before that search can take place. And that's what the Fourth Amendment says, even though it seems like that's not what's actually happening anymore. And the Bank Secrecy Act and the AML CFT regime wouldn't even really make much sense under the warrant requirement, because the warrant requirement is pretty strict. It says not only does the government have to prove probable cause to defend a search, they also need to particularly describe the place to be searched. So they're not supposed to ask, like, just give me all of Peter's bank records. They're supposed to say something particular, like, we'd like to know about his transactions on April the 25th, 1997. But of course, they just want all the information, and they get all the information under the Bank Secrecy Act. And so the question is, why is the Bank Secrecy Act and the AML CFT regime that it creates constitutional? And the answer to that is it goes back to 1974, when the Bank Secrecy Act was a brand new law. So back in 1974, there was this case, California Bankers versus Schultz. And the California Bankers Association and some other plaintiffs were saying, look, this Bank Secrecy Act, it can't be constitutional because it's warrantless searches. And the Supreme Court back in the 1970s said, well, no, it's constitutional because all of the records that we're collecting are records that you already gave up. You don't have them private to yourself anymore. You voluntarily handed them to a bank, and the bank thought that they were useful and therefore kept them as part of the ordinary conduct of its own business. And this carve out from the warrant requirement, where the government's saying, we can, without a warrant, get any information that people voluntarily hand over to a bank or other third party. This carve out became a huge hole in the Fourth Amendment. It is referred to generally as the third party doctrine, wherein once you hand your information over to a third party, like a bank or an ISP or Zoom or Gmail, you no longer have a Fourth Amendment right to not have that information searched without a warrant. The thing is that California Bankers versus Schultz, the case that created this standard, this third-party doctrine, and said that the Bank Secrecy Act, which created all this financial surveillance, the case that said it was constitutional, it was a close case. It wasn't an overwhelming majority at the Supreme Court. And so, 4 justices said it's constitutional because it's not a search. 3 justices said it's unconstitutional, it's warrantless surveillance, it should be overturned. They were in the minority. And 2 swing justices said, I think it's constitutional the way it's being applied right now, but not necessarily the way it's being applied in the future. And so that was back in the 1970s. And so what's interesting is those swing justices said, a significant extension of the regulations reporting requirements would pose substantial and difficult constitutional questions for me. At some point, government intrusion into these areas would implicate legitimate expectations of privacy. And a lot has changed since the 1970s. In 1976, there was another case, US v. Miller, and this sort of confirmed the third-party doctrine, that as long as you're voluntarily conveying information in the ordinary course of business, that information is no longer subject to a warrant requirement. But since these cases in 1976, the Bank Secrecy Act's regulations have been significantly expanded. And this is for a couple of reasons. The first big reason is people used to make very few transactions through banks in the 70s. Almost every transaction that a person made back in the 1970s would have been with cash. You go to the grocery store, you go to the bookstore, You buy a plane ticket with cash. You buy a train ticket with cash. You know, it's kind of crazy compared to the world we live in today, but this is how it was. And so when the Supreme Court said, okay, it's fine for all your bank records to be public, it was a very different matter. It was like, they're going to know you take out a mortgage. They're going to know your paycheck, but they're not going to know your day-to-day transactions because nobody uses banks to do those. It was before credit cards. Now, almost all of your transactions are made using a bank or third party. You're almost always going to be using a credit card. You're almost always going to be using Venmo or PayPal if you're not using a credit card. And maybe you're going to be using cryptocurrency. Almost nobody uses cash for anything anymore. And that means all of these records of those transactions, they're now part of this warrantless surveillance doctrine, unlike the cash transactions you were making before, which left no record. There's also new requirements since the 1970s. A big one is the suspicious activity report, where, as I was saying earlier, if you make a transaction over $2,000 and your bank, Bank of America, decides that it's kind of sketchy, they can say, you know what, the bank should file a report. That started in the 1990s. It was a response to earlier acts of terrorism than 9/11, of course, but it was a response to terrorism. And then it really took off in the wake of 9/11, with banks being very concerned about terrorist financing. And so you can see we go from a world where, and this only goes up to 2006, that exponential curve that you see there continues. We go from a world where the number of reports that are being filed to government, warrantless surveillance type reports, is in the, you know, low 100,000s to millions. And I think the last I saw was 7 million in the last year. So this is a lot of reports. And again, what does the Fourth Amendment say? Well, it says that you need a warrant, but for the third party doctrine. So the thing about the third party doctrine is it's under attack by the judiciary. The Supreme Court today, unlike the Supreme Court in 1976, is not really happy with the fact that the Fourth Amendment is almost doing nothing now. Like it stops the police from searching your home, which is important, but it doesn't stop the police from searching all of the things you do on the internet, because you do everything on the internet, and everything that you do on the internet uses third parties. And so in 2018, there's this case called Carpenter versus the US. And this is a case about cell site location data. So, you know, if I was to take my phone out of my pocket right now and walk down the street, I have AT&T. AT&T will know where I am the entire time. And it's not the GPS in my phone, it's the fact that my phone's using cellular towers. It will connect to at least 2 or 3 at any given moment, and then they can triangulate my exact location based on the signal strength that the radio in my phone is getting. And all of these cell phone companies, Verizon, AT&T, all the data providers collect this information about your location, keep very high fidelity records about your location constantly. And then there was this question, all right, well, if the police want to know, you know, where I was at some, you know, last Thursday, why don't they just go to AT&T and ask? Do they need a warrant to ask AT&T? It seems like that information was voluntarily conveyed to a third party, and so a warrant's not required. And this gets really bad for personal privacy because it can be much more intrusive than that. Instead of saying, we want to know where Peter was last Thursday, which is a somewhat reasonable request if you really think Peter was likely to be killing someone last Thursday or committing some other crime. I don't know why I jumped to murder. But if you just know that somebody got murdered last Thursday and you say to AT&T, we'd like to know everyone who was in this area at this point in time last Thursday, then you're really starting to get into the realm of civil liberties violations, because you're just asking for this huge amount of data about everyone's whereabouts at a certain given time. And so the Supreme Court said, you know what, for cellular location data, we really need a different standard. We can't just keep relying on this third-party doctrine to say that there's no warrant required for the police to collect this very intimate information about people. And what they said is, look, we've got this standard from Smith and Miller and the cases we talked about earlier, and California Bankers versus Schultz, where we say, you know, this information is already conveyed to the bank or to a telephone provider in the Smith case. And in that case, they just are already holding that information because it's central to their business. And is the cellular location data actually being held for a legitimate business purpose? And the court said, not really, because there's no limitation to the revealing nature of that information. If we have a record of the people that you're paying, it's not that intimate. And we know that the bank needs to know who you're paying because they need to be able to pay that person. A cellular company doesn't need to know where you are all the time to offer you services. So it's not actually essential to their business purpose. And so maybe this is why it doesn't fit into the third party doctrine. And so basically they said, information is not really kept for a legitimate business purpose if it reveals intimate details well beyond what is needed to provide the service. And then they also said, well, is the information being voluntarily conveyed by the subject of the search to the third party? And they said, actually, in the case of cell phones, people don't really voluntarily share their location data all the time because they use cell phones. And, I'm assuming lots of you are probably computer science folks. You might say, well, yeah, anybody who knows anything about cell phones knows that by choosing to use a cell phone, you're giving up your location data to the carrier. That's just going to happen. And so maybe it is voluntary, but the Supreme Court actually kind of addressed that argument by saying, look, you have to use a cell phone to participate in modern society. You'd be putting yourself at such a tremendous disadvantage to not use a cell phone. So it's really wrong to say that because you chose to use a cell phone, you give up your location privacy all the time. It was not a choice. It was not truly shared. And so this is the first time that the third party doctrine, since its creation in the 1970s, has been substantially curtailed. The Supreme Court's saying, look, if the information is not actually really voluntarily provided, then a warrant is required. And it's not voluntarily provided if a customer had no choice but to supply the information in order to participate in modern society. And so if we take this Carpenter decision, which is very recent, but changes the third party doctrine and apply it to cryptocurrency, we end up with a lot of interesting questions. So in order to engage in these questions, we got to go through some different hypotheticals. So the first one is, what are the privacy situations? What is the privacy relationship between a centralized exchange and their customer? So is it wrong for a centralized exchange to collect a bunch of information about their customer under the Fourth Amendment? And then what about a centralized exchange like Coinbase vis-a-vis a counterparty? So someone I'm paying, I'm Coinbase's customer, but I want to pay Dawn, and Dawn gave me an Ethereum address, and it's actually like her MetaMask account that she controls directly. There's no third party there. Is it okay for Coinbase to collect this information about Dawn, who's not her customer? That's our second question. Our third question is, well, what about a software developer? Whether it's a developer of a protocol, like a developer of Zcash or Tornado Cash, can we force them to collect information about their users? Or what about DEX code? So if I was using Uniswap instead of Coinbase to transact, should the developers of Uniswap be forced to KYC and identify all their users? And then finally, what about a transaction between two people who are holding their own cryptocurrency who don't use a third party at all, like Coinbase? Can those transactions, can we be forced to reveal information about ourselves without a search warrant rather? So these are our four big questions. So first, centralized exchange vis-a-vis their customer. So in this situation, Alice is a customer of Kraken, and Bob is a customer of Coinbase, and Alice wants to pay Bob. Now it gets a little different in a world where Alice is not a customer of Kraken and wants to pay Bob at Coinbase. And so in this world, Alice just shows up to Coinbase as an Ethereum address that sent a valid transaction to Bob's wallet, really to the omnibus wallet at Coinbase, not to Bob directly. And so in this case, can we really say that Alice ever voluntarily conveyed her information to Coinbase and allowed Coinbase to hold it for a legitimate business purpose? I don't think so, because this is the whole problem. This is why we're seeing regulators struggle with quote unquote unhosted wallets. Can Coinbase as a third party require information from Alice? Coinbase has no contractual relationship with Alice. Coinbase has no duty to Alice of privacy or anything. And so in our opinion, under the reasoning explained in Carpenter, it would actually be unlawful under the Fourth Amendment for the government to require Coinbase to collect Alice's information, because Alice never voluntarily provided to Coinbase, and Coinbase has no legitimate business purpose to hold that information. All they need to know is that an Ethereum transaction was validly signed. They don't need to know who it came from. So let's get then to software developers. Software developers identifying their users. You can still make a Fourth Amendment argument here. You can say that there's no legitimate business purpose for a software developer to collect information about the people who use their software to make transactions. That information wouldn't be voluntarily provided because people just choose to use open source software or choose to use a protocol. That doesn't mean that they're signing up to have their transactions surveilled, especially if that protocol is essential to modern life. As we generally imagine, if Ethereum or Bitcoin or any of these cryptocurrency networks takes off, it might be fully essential to modern life in the same way that a cell phone is essential to modern life. And then there's also the matter of the First Amendment rather than the Fourth Amendment. The First Amendment says, look, you can't force people to express ideas that they don't strongly hold. You can't tell someone you're now going to be a communist. You have to talk about communism all the time. And that's called compelled speech. And it's a doctrine for a very good reason, because it's sort of the negative of our free speech doctrine, which is, look, the government can't before you say something, force you to get permission to say something, or can't just censor you outright and say you're not allowed to say certain things about Joe Biden, or you're not allowed to say certain things about Donald Trump. That would be a violation of our First Amendment freedoms. Compelling someone to say things that they don't want to say is also a violation of our First Amendment freedoms. And so if the government was to compel a software designer, say like Uniswap for DEXs or the Tornado Cash developers for Tornado Cash, and say, you know what, you wrote tools that are a little bit too good. You have to break those tools. You have to put a backdoor in so that we can actually uncover, private transactions if they're not otherwise visible on the blockchain. This would be compelled speech. And there's a case that started to go down this road, but then the government backed down against Apple with the iPhone. So that was a pretty, a pretty straightforward request. It was in the wake of the San Bernardino acts of terrorism. The terrorist was dead. Their phone was locked. The DOJ or the FBI wanted to learn more about this terrorist who committed these terrible acts, and said, Apple, you gotta unlock this phone for us. And the user apparently had a fairly strong Apple password or iOS password, so it wasn't a trivially easy thing to just brute force. And if you enter too many wrong passwords in iOS, it locks down and it deletes the phone. And so the FBI went to Apple and said, you've got to break this phone for us. And Apple said, well, look, in order to change our phone, we'd have to load different software onto it that is validly signed with our developer key, or the phone will reject it. And what we'd be doing is creating a tool that will mean that law enforcement would always be able to download anybody's contents of their iPhones without a warrant, without any kind of control. And so we don't want to write that software. And the lawyers that Apple hired actually started writing briefs that said, look, that would be compelled speech. You cannot force Apple Computer to write this code that it doesn't believe in, that it actually thinks is very bad for cybersecurity and for the world and for freedom. The government actually finally found somebody who said they were able to unlock the phone. I think they did somehow, so there might have been some vulnerability in an iOS security model. And then because they were able to get the information through that route, paying a lot of money to the security firm in the meantime, they dropped the order against Apple. They said, all right, you don't need to write software after all. And so we didn't go to court with that. But I think this would be another interesting avenue of legal reasoning if the government was ever to come to Tornado Cash developers or Uniswap developers or Zcash developers or Bitcoin developers and say, you've got to write this backdoor into the code. They would definitely be able to challenge on First Amendment grounds, I think. And so the last thing I wanted to talk about on this list before we get to Tornado Cash is, what about the context of peer-to-peer transactions? And this is implicated collecting information about peer-to-peer transactions is implicated in a recent change to the law that happened last summer when the infrastructure bill passed Congress. And so the infrastructure bill included something called 6050I reporting. Oops, there it is. And so 6050I before the infrastructure bill was about returns you'd have to file to the IRS every year for cash transactions that you received that were above $10,000, or cash transactions that you made potentially that were above $10,000. And it wasn't just a yearly return. You actually had 30 business days, I believe. I think that's still the current standard to make that return in the wake of getting a payment for $10,000 as part of your trade or business. So if I have an antique store and I have a really nice desk, I mean, like Thomas Jefferson sat at this desk, you could have this beautiful desk in your home for the low, low price of $10,001. And then the person who wants it's like, okay, Peter, I'll buy that desk. Here's $10,001 in cash. I am now obligated, even though I'm not a bank or a financial institution, I'm just an antique dealer, I'm obligated to now file a report. And in that report, I need to collect, you can actually see the information, some of the information here, the name, the address, the taxpayer ID or social security number, the date and nature of the transaction, the amount of cash received, et cetera. Very personal information about you, just for a face-to-face cash transaction. And this has been the law for decades now, and it's only applied to cash. What the infrastructure bill did was say, you know what, we've got that cash and coin reporting obligation, we're going to apply it to crypto. And we fought about it in Congress. You may have seen headlines last summer. We almost got a compromise from the Senate at the last minute that would have removed this, but ultimately we couldn't get the votes. And so this is now law. It goes into effect in 2024, but it's backward looking for the tax year 2024. So starting in 2023, if you send or receive more than $10,000 in crypto, you're obligated to learn the name or address of the person you're transacting with and social security number, and file a paper form. There's no electronic filing option in order to report this transaction to the IRS. And that obviously is going to cause a lot of problems in the world of crypto, because actually a lot of people make $10,000 or more transactions somewhat often, and quite often they're making those transactions with, say, a robot who doesn't have a name or social security number. Or they're mining the blockchain and getting a block reward. Who do you report? Who's the counterparty in that case? So this has got a lot of problems, and most fundamentally, it's just very bad for privacy. And under our Fourth Amendment analysis from before, it doesn't really make sense, because if we don't have Coinbase in the picture, we just have Alice paying Bob directly, and they all hold their own keys, there is no third party. There truly is no Bank of America or Venmo who I'm conveying my information to. They're holding it for a legitimate business purpose, and therefore the government can collect it without a warrant. This is really a situation where they're coming directly to me, the government, and saying, you need to tell us about your transactions, but they don't have a warrant for that under 6050I. They're not required to get a warrant. So we believe that the 6050I reporting requirement for crypto, and maybe even for cash, but because we're Coin Center, we're challenging the crypto aspect, is unconstitutional. And we've already filed a lawsuit in the Western District, in the Sixth Circuit, in the District of Kentucky, in federal court to challenge this. And we're still awaiting the government's response. At this moment, they've requested another 90 days to file their answer to our complaint, where we allege that the amendment is unconstitutional. So that's ongoing. The question of self-hosted wallets and whether a centralized exchange can collect information about customer counterparties is sort of on the back burner, because that was proposed 2 years ago by the outgoing Trump administration in a rulemaking, but they never finished their rulemaking. There was a lot of complaints from Coin Center and from the Electronic Frontier Foundation and other people. And they were sort of like, all right, well, back off. We're going to just hold this. And when the Biden administration came in, it wasn't a priority. So we're still waiting for a final rule on that question. If the final rule says that Coinbase has to collect information about people who aren't their customers, then we're going to challenge that on Fourth Amendment grounds as well, probably. And, it's actually a really good time to challenge these privacy encroachments, because as much as the court has done a lot of things that I think a lot of people are upset about, and rightly so, the court also does have fairly strong opinions about the Fourth Amendment and the need for a warrant requirement in searches. So I'm not going to go into the larger issue of everything about the Supreme Court, but suffice it to say that the justices we have now have already signaled that they don't believe that we should continue to maintain the third party doctrine. So this is Gorsuch's dissent in Carpenter. So Gorsuch is dissenting in Carpenter, not because he disagrees with the outcome, that there should be a warrant requirement for cellular or location data, but because he thinks it should have been an even stronger outcome, that there's just no third party doctrine anymore. Let's just get rid of the third party doctrine rather than saying that for cell site location data, there's no third party doctrine. And I'm not going to go too much into
thanks a lot. So maybe we can take a moment to answer some of the questions.
Yeah, and then we can answer questions about all that, and then we can get into the Tornado Cash stuff. I think that'd be good.
Yes, that'd be great.
Sounds good. So we have some questions on Tornado Cash as well, but I'll ask those after. It seems like you have some slides on that as well. So the first question that I've seen here that's really interesting is with regards to the argument of ubiquity with respect to cell phones being a ubiquitous technology that is required for participation in modern society.
Yeah.
And it seems clear that this is not yet the case for cryptocurrency, that you can, and most people do, go about their day-to-day lives without interacting with crypto. How do you see that as potentially affecting your argument with respect to cryptocurrency regulation, in the sense that interacting with crypto can be seen as highly voluntary for the time being?
Yeah, so it's in some ways difficult, but in some ways it's not. So you're absolutely right that at the moment, like, cryptocurrencies are not essential to modern life, but some form of electronic transaction is essential to modern life, right? If you want to pay someone in Ukraine right now, you're going to have to rely on a third party like a bank or a wire provider, and most of those aren't even working right now because of the invasion. Or you're going to use cryptocurrency. And we've actually seen a lot of cryptocurrency donations to the government of Ukraine, to people in Poland who can buy medical supplies and move them across the border, a lot of philanthropic transactions being done using cryptocurrency because the banking system isn't working. So there are definitely situations where the user of cryptocurrency may have no other option, and what they're doing is completely legal. And the notion that because there's no third party, they shouldn't be able to do that, or they should have to surveil themselves rather than have a third party surveil them, to me just doesn't meet constitutional scrutiny, for the exact same reason in Carpenter, is because if your business is, aid to a war zone in Ukraine, you're a nonprofit, a legally incorporated, completely a legitimate business in the US, or charity even, and this is your only way to get money to Ukraine, then simply choosing to use this technology versus another shouldn't automatically sign you up for some sort of level of surveillance. Would be the argument there.
Okay, great. Now there are some questions about the sort of details, logistics of these regulations as they stand. One thing is whether there is a clear test that has been established by the courts for a technology becoming ubiquitous, or was it just that the justices alleged that cell phones are ubiquitous? How would we know that crypto has indeed become a ubiquitous technology at some point?
There isn't a firm test, and this is actually the conservative justices' problem with the third party doctrine. It's all based on CATS, which is this reasonable expectation of privacy test, which says that you lose your reasonable expectation when you voluntarily provide your information to a business and the business holds it for a legitimate purpose. The conservative justices think this is nonsense in that it's a completely, it's an impossible test to adjudicate because everyone actually has a different level of expectations about privacy. They're very subjective, they're very personal. My example earlier of like the privacy needs of a philanthropic nonprofit that sends aid to Poland for stopping, for because of the Russian invasion, their privacy needs are very different than an ordinary person just buying groceries, because they're probably going to be a target of hacks and attacks from Russian cybersecurity or Russian hackers. So, the conservative justices don't like the subjective test that was set up by CATS and the third-party doctrine at all, and they'd rather just wipe it out. And the conservative justices have the majority on the court. So if this question's being asked for like how exactly can we meet this Supreme Court test, my answer would be don't bother. Find a way to bring an argument to the court where the court will say, you know what, this test is, we're getting rid of this test. It's done. We're overruling it. And what the conservative justices in the Supreme Court would prefer is a property-based or trespass theory-based notion of the Fourth Amendment, which would say that like there's this case called Ex parte Jackson, and this is about messages you send in the mail. And so this is an old case. I think it's in the 1800s. And in this case, somebody was at a government agent was at a post office, basically just opening letters and packages to see if there's, something illicit in them. And the Supreme Court said, look, we can't have that. Letters and sealed packages in the mail are as fully guarded from examination and inspection, except as their outward form and weight, as if they were retained by the parties forwarding them in their own domiciles. And the legal theory here is if you were to open someone's sealed package in the mail, you would have an action under trespass, the common law, civil law of trespass, where, if some not a government person, just a random person was to go through my mail, I could sue them for a trespass to chattel, trespass to property. If someone came into my home, I could sue them for trespass. If somebody took my photograph in an otherwise private environment, I can even sue them. That's a tricky one, the so-called privacy torts, but it's there. There's a lot of old common law reasoning about privacy. And the conservative justices would say, you know what? If a private person can't do that, and if they'd be sued in a civil court, then that is what a trespass is. That is what a search is for the government when the government does it to you. And so arguably, and the conservative justices want this to apply to all kinds of even modern technologies, despite being usually originalist or textualist justices. So in a case that Scalia wrote the opinion for called Kylo, the question was about sophisticated thermal imaging cameras. It was, what if we point the thermal imaging camera at a home, and so we don't trespass into the home, but we can see into the home, we can see that they're growing marijuana in this room, or we can see that they're walking around over here. Is that a search? And in Kylo, they said yes. And Scalia's point in this quote is that it doesn't matter how good the view into the home is. We can't start getting into like hard questions about whether like the image was blurry enough or sharp enough that it starts violating someone's reasonable expectation of privacy. Any looking into people's homes beyond just the windows, which are obviously open to inspection from the public, is a violation. So it's a very strong notion of privacy. It's a very fun quote from him saying, a sophisticated thermal imaging camera might disclose, for example, at what hour each night the lady of the house takes her daily sauna and bath, the detail that many would consider intimate. And a much more sophisticated system might detect nothing more intimate than the fact that someone left the closet light on. And so, Scalia here is saying it shouldn't matter what the technology is, it's what people do with it. If you're looking into someone's home, you're searching their home, that's the end, it's a trespass. And so I think those are the standards that we're going to be dealing with over the next 10, 20 years from the court. And so for the cryptocurrency transaction, if I was to make a Zcash transaction, I've basically, in a very real way, packaged something up into an envelope and sealed it. And to say that the government should be able to unseal my envelopes or force somebody like the developers of Zcash to break the encryption to unseal my envelopes without a warrant, it just goes against hundreds of years of trespass theory and privacy that I think the Supreme Court wouldn't stand for.
Great. All right. I'm loving the legal oriented discussion here. Last question for now on this regard. We got a jurisdictional question. So what exactly is the theory of jurisdiction over cryptocurrency that the federal government is using in these cases? For something like Ethereum or Zcash, which is clearly a US based foundation overseeing the system, maybe there's an argument. But what about something like Bitcoin, where it's not known, the system is not owned by any entity. It's not known if it was even created in the US. So what is the theory for saying that the US government would have the authority to regulate that system? Is it an interstate commerce theory or something else?
So in the case of the Bank Secrecy Act, the jurisdiction is subject matter based on information that would be useful in the course of criminal or tax investigations. Presumably, those are going to be criminal or tax investigations dealing with US persons. And at that point, the location of the network, Bitcoin, the SWIFT interbank settlement system, is sort of irrelevant, because if you have a US person who is being investigated for money laundering or something like that, they have jurisdiction over you, right? Now, it gets a little bit more complicated if it's non-US persons who are doing these things. I think if you're a non-US person and you happen to be like not paying your taxes, I don't think generally the US government's going to care, right? So we can sort of exclude that particular fact pattern. I think where people really think about jurisdiction a lot is not in this financial surveillance context, but more in the securities law context, where a team of developers in, let's say, Turkey decide to develop a new cryptocurrency network that does something flashy and interesting and different, and they sell their token maybe globally. Some Americans buy it, or maybe they buy some future right to it in like a SAFT sale or Reg D offering or something like this. And this company has no employees in the US, they have no business in the US, but these transactions, according to the SEC, are securities transactions because they claim that the token is an unregistered security. It fits the Howey test. So this is a different area of law, but this is a very relevant one from a jurisdictional standpoint, because the SEC's right now doing this quite often. They're going after folks who are abroad, who have sold to Americans. And if you've actually sold directly to an American, the jurisdictional case is pretty easy, because the SEC definitely has jurisdiction over people who injure Americans, even if they're foreigners. If you've only ever sold, however, to people overseas, and somehow some tokens found their way back to US persons, but you never actually sold them to those people, you never wanted them to have it, then the SEC has a harder fight here. And this is where we've seen them be very entrepreneurial in the way they frame why they have jurisdiction. The most recent case, which is a securities Section 5 fraud case for like a Ponzi scheme done using cryptocurrency, the SEC said some of the purchasers were Americans, and really they probably could have just left it at that. But also, the transactions are happening on Ethereum, the majority of nodes of which are on US soil, and therefore we have jurisdiction over those transactions as well. And that is a very broad interpretation of their jurisdiction, but it's not an unusual one. This goes back to sort of the 1980s and 1990s, where the Southern District of New York, being the district where Wall Street is, sort of saw itself as the global financial cop on the block, and was perfectly happy to say, because it doesn't matter, you're not American and the people you're paying aren't American, It all went through a bank that is here in Manhattan. And so we can go after this transaction if we want to. And so there's been an ongoing fight about that predates cryptocurrency. Cryptocurrency makes it a bit more extreme. And honestly, I don't think that kind of argument that if there were really no contact with US persons, the only contact with US soil is the fact that the transaction was validated on the Ethereum blockchain and the majority of nodes are mining Ethereum or validating Ethereum transactions are in the US, I don't think it would stand up in court. That's different. That's far more attenuated even than the argument that like a bank in Manhattan was at one point involved in a transaction involving non-US persons. Because at least they're having some relationship with the bank, because it's not a trustless system, right? In a trustless system, like you don't have a relationship with the nodes that relay your transactions. You don't have a relationship with miners who validate your transactions. Yes, they collect a fee because of your transaction, but had they not put your transaction in a block, some other miner would have. So they're not the but-for cause of the transaction going through, and you don't even know who they are. They're not in privity with them in any way. You're not in any kind of contractual relationship with them.
Great. Well, we'll ask, this seems to be sort of in the weeds of the current regulations, but because people seem to be wondering, how easy is it for someone to get around the reporting requirements currently just by doing things like making several small transactions instead of a large one? Obviously, this sort of case has been covered by rules in traditional finance, but do similar restrictions apply to crypto?
Yep, that would be called structuring, and it is a crime, both at the federal and probably in most cases state levels. So structuring is defined as making a series of transactions in order with the knowledge and intent to evade a reporting requirement. So, if you happen to make a bunch of small transactions, but you had no intent to evade a report, it's not a crime. In fact, the Supreme Court heard a case about that where someone said, look, I'm being held liable for structuring. I was just making small payments. I wasn't actually trying to avoid anything. And Justice Ruth Bader Ginsburg, in one of her later opinions, actually said, that's simply not something that can be criminalized. You can't criminalize behavior that's not actively trying to perform any wrong, But if they can prove that you had knowledge and intent because you wrote an email somewhere that was like, look at this suspicious activity reporting requirement. As long as I just send you 3 transactions instead of 2, we won't have to worry about it. If they find that email, you're going to jail, or you're getting a fine or something. So structuring, it's illegal. All
right, with that, let's proceed to talk about smart contracts, and then we can ask some questions that we have prepared on the topic of smart contracts and policy.
So you mean Tornado Cash, right?
Is Tornado Cash the only one you were hoping to cover?
Well, that was the last thing I was going to cover, is Tornado Cash and the OFAC sanctions that came out last month.
Got it.
Yeah,
a lot of.
If you can continue with the Tornado Cash, right? And then we can the questions later, right?
Let's proceed. I think some of these questions are about regulations for smart contracts more broadly, but I suspect they'll be applicable to Tornado Cash as well.
Okay, great. So I'm going to presume that this audience generally knows the difference between Tornado Cash as a privacy tool and Blender or some custodial mixer. Is that a reasonable thing to presume?
Maybe you can just do a quick.
We've got notes. Okay. So Tornado Cash is a tool that's been around on Ethereum for a while, and it exists at a series of 38 smart contract addresses on Ethereum. And a traditional mixer is, in the Bitcoin context, for example, something like Blender. And in this context, I'm just a person. I might be anywhere in the world, and I have a Bitcoin address, and I say, anyone who sends Bitcoin to my Bitcoin address, I will hold it for them. And if they ever want it back, I will sufficiently mix it with other transactions coming in, and so that the UTXO set becomes, confused and unreadable, and then send it back to them. And then they will have the benefit of having a link between their sending address and their receiving address on the blockchain severed, because it all went through this big wallet that I, the mixer, control. So that's a typical custodial mixing service. And that, under US regulations, is a financial institution, is a money services business. They need to know their customers and file reports and things like this, because really they're not any different than Coinbase. Coinbase is just one big omnibus wallet, right? And money goes in, money comes out. You can't follow from one person to the other who it was. Coinbase doesn't advertise itself as a mixer. They advertise themselves as a custodial wallet, but functionally what they're doing is the same. And so mixing services that are saying, we're here to anonymize your Bitcoin traffic or launder your money even, are probably not registering with FinCEN and filing their suspicious activity reports, and because they're designed to be, these tools for facilitating, private transactions. And so in that context, they're violating the law because they're custodial, just like Coinbase, and yet they're not registering with FinCEN. They're not identifying their US customers. They're not filing reports. And not only that, they may be deliberately furthering, truly horrible activity like terrorism or international money laundering for arms dealers or a number of other things. And so last May, there's this part of Treasury called OFAC, the Office of Foreign Asset Controls. And I'm talking about the US Treasury. And the Office of Foreign Asset Controls is the part of the US government that enforces our sanctions laws. And our sanctions laws are how we do a lot of foreign policy these days. So we say, like, Americans aren't allowed to buy a house from Vladimir Putin anymore because he's a sanctioned person. Or you're not allowed to send money to this person in Iran because Iran is a sanctioned country. And the statute that enables the government to do that is the International Emergency Economic Powers Act. And it basically says that the president can declare emergencies like the Iranian crisis or North Korean hackers are attacking US servers or any number of other things, and then identify foreign persons and say that Americans are no longer allowed to transact with that foreign person. That's what the law says. And it's been on the books since the 70s. In fact, it's a slight change to the law from the Trading with the Enemy Act, which goes back all the way to the early 20th century. And so it's this power to just stop Americans from trading with the enemy, if you will. Now, when you take your custodial mixer, like Blender, which I was describing earlier, you can put that on the OFAC list. And the OFAC list is a list of people that Americans aren't allowed to transact with under IEPA. And you can say, well, the people who run Blender, they're foreign persons, because they were Russians, I believe, and they're facilitating money laundering and doing other crimes. And so therefore, Americans cannot transact with Blender, the people running Blender, or those Bitcoin addresses. This wasn't the first time last May that they added Bitcoin addresses to this list of people Americans can't transact with. In 2018, they actually added 2 Bitcoin addresses that were the Bitcoin addresses of Iranian nationals who were committing ransomware attacks and getting paid from the ransomware at those Bitcoin addresses. And all of these are fairly routine uses of the sanctions powers in CoinCenter's opinion, because you're identifying a foreign person as an enemy or a terrorist, and you're saying Americans can't send money to that person anymore. Fast forward to last August, and last August, OFAC adds Tornado Cash to the sanctions list. And Tornado Cash is fundamentally different than Blender. So let me briefly explain why. The addresses that allow you to have privacy when you send money to our Tornado Cash address and then take the money back out are not in the control of a foreign person. They are not a person at all. There was some person who developed the software at those addresses at some point in the past, but once published to the Ethereum blockchain in the way that they were published to the Ethereum blockchain, they are immutable. They can't be changed. They can't be deleted. It's just a software tool that now exists in the world. And anyone who wants to maintain their privacy while using Ethereum is free to send money to those addresses. It's a smart contract. It's a robot, so it'll automatically return the money to them if they can prove that they have a zero knowledge proof that they were the person that put money in, and that money in and money out from a public blockchain perspective, from a third-party perspective, can't be traced. But there's no point in this transaction where if I'm using Tornado Cash to protect my own privacy, I'm paying a foreign person or transacting with a foreign person. And so Coin Center would argue that this usage of the International Emergency Economic Powers Act to sanction Tornado Cash is not done under the law. It's done ultra vires. It's done outside of the law, and therefore it can be, we can petition a court to say that that listing of Tornado Cash as a sanctioned entity needs to be nullified, and people should still be able to use that smart contract. And we have three big arguments as to why. The first is that it's outside of their statutory authority to list those smart contract addresses on the SDN list. And this is because the authority that OFAC relies upon, OFAC's only allowed to do things that Congress sent them there to do in the International Emergency Economic Powers Act. And that authority says that they can block property in which some foreign country or national has an interest. And the fact of the matter is that the Tornado Cash addresses that were added to the SDN list are not the property of a foreign person. They're not property and they're not a person at all. They're just a software tool existing at an address. And the Supreme Court, as it exists today, is probably favorable to this kind of statutory law argument because they are quote unquote textualists. They believe that when Congress writes a law, they really mean what they say with the words. We can't just sort of pretend that the words mean a little bit more. So when Congress said you're allowed to block property in which some foreign country or national has an interest, it really can only be limited to that kind of a block. And so when I use Tornado Cash, for example, I send money to a Tornado Cash smart contract. I take the same money back out later. There's no link between those two transactions on the blockchain, but at no point did I transact with property in which some foreign country or national has an interest. It's just me using my own property, using a software tool that's available on the Ethereum blockchain. So we'd argue that it's impermissible for them to actually put Tornado Cash on that list. We'd also argue, second and third, that this violates due process. And so the due process clause of the Constitution says that, look, before the government can take my life, liberty, or property, I must be given notice and the opportunity to be heard and a decision by a neutral decision maker. And the fact of the matter is, when something shows up on the OFAC list, there's no notice apart from it being on the OFAC list. There's no opportunity to be heard, and there's no decision by a neutral decision maker. There isn't a case about this. The only person who can challenge that listing is the person who got listed. And the interesting thing about Tornado Cash is there's no person that's been listed. The developers of the software probably can't challenge it because they don't even control the address itself anymore. The users of the software also can't challenge it because they aren't the person that's been listed. They can apply for a license, like permission to use this software tool now that it's been added to the list, but that's not the way OFAC's supposed to work. It's not supposed to allow the Treasury to just identify tools that Americans need to get a license to use, because that starts to look like something other than sanctions. It starts to look like a limitation on people's capabilities to use speech or software. Now, in the national security context, due process rights are often weakened because the government, the courts say, well, the government has a really strong, compelling interest here because they want to stop terrorism. And so maybe we don't need as much process to deprive people of their property or liberty or things like that. And there's this balancing test in the Matthews factors that describe like substitute process. I'm not going to get too much into this unless there's questions about it, but I think, the long and short of it is, even under this weakened standard of due process, the substitute process that the government has put in place, you can always get a license, this sort of thing, is not adequate to protect people's liberty interest. And then the final argument we're going to make is, that this chills speech. And, this should be obvious that it chills speech for a couple reasons. When the sanction of Tornado Cash was announced, a Treasury official was quoted in the Financial Times as saying that the purpose of this sanction is to actually chill speech, is to actually send a critical message to the private sector about risks associated with mixers, such that people will stop using Tornado Cash to inhibit Tornado Cash or any sort of reconstituted versions of it to continue to operate. And so it seems like this is transparently evident that the officials in Treasury who pushed for this sanction don't just want to stop people from paying a foreign person. They want to stop people from using certain software, which we would argue has a tremendous chilling effect on speech. You saw GitHub delete the accounts of the original Tornado Cash developers. You saw people questioning whether they were going to be liable as software developers for having written the code. A developer was actually arrested in the Netherlands, possibly not related to US charges, possibly Dutch charges. It's still unclear because he hasn't been charged and he's still being held, which is outrageous in its own sense. And then another thing that's worth mentioning, it's not just about chilling speech as in chilling people's right to publish code. Money is also speech, according to the Supreme Court, and it's also a form of association. And you have a right, actually, under the US Constitution and the associated case law, to make anonymous donations. And this right is originally derived from the First Amendment, but it was first really highlighted or explained by the Supreme Court in interpreting the First Amendment in a case NAACP versus Alabama. So the NAACP is a civil rights organization back in the 1960s. They're fighting for desegregation and things like this. Alabama comes to the local NAACP chapter and says, we'd like a list of all of your members in Alabama who donate money to your organization. Suffice it to say, we know what's going on here. Alabama or the local authorities may not just want to make sure that these people are paying taxes. They probably want to know exactly who is advocating for desegregation so that they can burn a cross in their yard. Like, that's just what was going on back then. And so the Supreme Court said, look, after it went all the way up to the Supreme Court in a court challenge against the Alabama law that said that they had to disclose their donors, Supreme Court said, look, if we're going to have a democracy and civil rights, there has to be an ability to have anonymous association for people to donate to, support, attend meetings, join organizations, but not have their identity and their information automatically disclosed to the government when they do so. And so in the Tornado Cash context, Coin Center has actually received donations from Tornado Cash addresses in the past because some of our developers have wanted, some of our supporters have wanted to donate anonymously. And so we would argue that by identifying Tornado Cash as this tool for privacy as sanctioned and and criminal to use, they're substantially chilling constitutionally protected donations to organizations like Coin Center. There was a guy in New York who donated to Planned Parenthood using Tornado Cash right after the sanctions happened. They're chilling lots of protected association and protected speech by taking this action. And it's not even being done under color of law because they don't have the statutory authority to do it in the first place. So that's my roundup of Tornado Cash and the potential challenge that we're probably going to bring very soon. I'm not going to give too many more details about our challenge because we want to make sure we get our ducks in a row before we come out publicly and talk about it. I will say that Coinbase has already challenged the designation, and it's in the Western District of Texas right now. They've actually filed their complaint, and they've made very similar arguments to the arguments I'm making here.
All right, thank you very much. We have a lot of interesting questions on Tornado Cash and also on smart contracts more broadly and the ability to regulate them. I want to start by just framing the discussion with a question about Tornado Cash, which obviously can be used for things like money laundering and nefarious purposes, but also for legitimate reasons. Beyond the broad argument about privacy that you might make to a court or a judge, if you were trying to convince the average citizen that this is a useful tool that can be used for legitimate purposes, what is the cleanest use case that you would give for Tornado Cash? That this is, to argue that this is a tool with legitimate uses, not just not just nefarious purposes behind it?
I think the first thing I'd reach to right now, given geopolitical events, is making donations to the government of Ukraine or to aid organizations who are supporting the defense of Ukraine against Russia's invasion. So there's, very strong evidence that cryptocurrencies have not been useful for Russian oligarchs to get money out of Russia because there's just not enough liquidity to move the money that they want to move out of Russia. And when they do it, it's very public. There are also very strong arguments that cryptocurrency donations are actually like small donations, which aren't necessarily as public, especially if they go through Tornado Cash, have been a major help to the war effort. The digital director of the Ukrainian government has testified before Congress, saying that they were able to receive donations using Ethereum and Bitcoin at a time when they weren't able to receive donations using the correspondent banking system because of the infrastructure collapse in their country. And the fact of the matter is, lots of people who have donated to Ukraine have noticed suspicious things happening to their Ethereum addresses after they've made the donations, especially people who've donated large amounts. Like unsolicited NFTs show up, a lot of other stuff shows up. And it is not at all unlikely that these are coordinated efforts by the Russian intelligence services to sort of grift or attack or otherwise take revenge on donors to Ukraine. And so if you have a public Ethereum address that has your name attached to it, that has maybe an NFT attached to it, if you're Jimmy Fallon or Shaquille O'Neal, there's a lot of transactions that you're going to want to make using Ethereum that you do not want linked to your personal address, maybe for very legitimate purposes. So I think that's the best argument. And we actually do know several folks who might be challenging the designation, who have helped people make these private donations using Tornado Cash and want to fight for their right to be able to make private donations to a legitimate effort.
Okay, thank you. So you mentioned that the current sanctions on Tornado Cash are specifically on the sort of smart contract addresses associated with Tornado Cash. Is there a potential for the government to simply sanction the concept of Tornado Cash, or even the concept of a mixer? And if not, what would stop someone from republishing this contract at a different address that wouldn't fall under the sanctions? Maybe even changing the address on a daily basis, for example. Yeah.
So I think that to answer the second part first, if we just end up with piecemeal, like these addresses are bad, these addresses are bad, there will be people who republish the software. And OFAC has even said it's not a crime to republish the software because they know that if they did, they'd end up with First Amendment, scrutiny. And I think what it means is we're signing up for like a protracted game of whack-a-mole. Like you take this down and then it just pops up over here. Now you got to take this down, which is not good for anyone. It's not going to be effective from a sanctions standpoint. And it's not going to be good for civil liberties because a lot of people might get hurt in the process of playing whack-a-mole. I think that there is a legitimate point to be made, though, that the value of a tool like Tornado Cash is in large part based on the size of the anonymity set, so the number of people using it, just like Tor, just like most privacy tools. And therefore, it will be somewhat difficult for a new alternative to Tornado Cash to emerge and gain enough usage that it has a viably large anonymity set to achieve the privacy that Tornado Cash achieved. And so for that reason, I think we should fight actually to get Tornado Cash delisted from the OFAC list so that people can continue to use it for legitimate purposes. Going back to the first question, which is, can they list a sort of concept or idea rather than a specific address? I don't think they can list a specific address. Because again, this is our statutory challenge. They're really only allowed to list foreign persons or foreign entities that have majority foreign ownership. And so I already think they're over the line as far as what they're allowed to list. And I think if they were to list something like Zcash as an entire protocol, or privacy coin as an entire bundle of protocols, that it would just be self-evidently wrong that like that is not a person. You can't claim that as a person. Now, maybe they want to claim that it's an entity and that the miners on the network are jointly and severally the creators of the entity and they maintain it and things like that. But to me, that's a huge step in a bad direction. And there'd be, I think, a lot of challenges as to whether that's a legitimate sort of interpretation of how a cryptocurrency network structures itself and whether any of those people are actually culpable and whether it is an entity, because I don't think it is. And the thing is, like, at the end of the day, we're talking about tools, right? We're talking about this series of smart contracts with this amount of software allows people to do all of these things. They're not supposed to be putting tools on the OFAC list. There is another area of US sanctions policy and national security policy that deals with tools that shouldn't be imported or exported or discussed publicly. And this is ITAR, and it's about trafficking in munitions. So if you're a defense contractor and you invent a new atomic bomb, you're not allowed to take that atomic bomb blueprints even and necessarily, go to a foreign country. And we've seen in the past attempts to use ITAR to limit the import-export of weapons-grade cryptography. And this goes back to the 90s with RSA Perl and PGP, and attempts to tell the software researchers, some of them academics, I think, was Bernstein even at Berkeley? I'm not sure. One of the cryptographers that challenged these rules said, look, you can't stop me from publishing open source code and information about my crypto system because that's a violation of my First Amendment rights. So there is this whole other regime that is more set up to specifically tell people that they can't share or use or import or export certain concepts, i.e. munitions or intellectual property related to weapons. But it's already been found unconstitutional to use that to actually stop the spread of something like strong encryption as an idea and as a tool that's useful in the world. I think it would also be wrong to do it here. So that's a sort of a long-winded answer. I don't think they can do it using IEPA, which is where you're allowed to sanction persons. And I think doing it using ITAR, which is where you're allowed to sanction or block the import-export of ideas or munitions, rather, I don't think you can use it purely for ideas. And we saw that back in the 90s.
All right, that's an excellent response. Thank you for that. With respect to the logistics of how these current sanctions are imposed, how closely associated does a coin or transaction need to be with a sanctioned address in order for it to be, untouchable by a U.S. entity? If there was a transaction that had previously gone through Tornado Cash, several transactions ago, is that still considered sanctioned because it could be in the sort of pipeline of money laundering? Mm-hmm. And if so, do you just get an increasingly large part of the blockchain that is untouchable to centralized entities?
Yeah, it's a great question. I think I saw somebody did the math on this, and something like 70% of all Ethereum addresses are 5 hops or fewer from a Tornado Cash address in the transaction graph. And it's something like 40 are like 2 hops from a Tornado Cash transaction. So yeah, it becomes like a large amount of Ethereum, right? For anybody who has concerns about this, because maybe they've received transactions recently that are adjacent to or directly from Tornado Cash, you should definitely get a lawyer. So I just want to say that up front. I'm not your lawyer. You should get a lawyer. But speaking generally, the law says IEPA and the implementing regulations under the cyber executive order that Obama promulgated against North Korean hackers, which was the basis for this particular listing. In all these cases, they talk about Americans not being allowed to transact with a person. or an entity. And so a strong rebuttal to that in the Tornado Cash context would be, even if I get a transaction straight from Tornado Cash, it's not from a person or entity. So this order from OFAC is extra legal. I don't have to obey it. In fact, I can challenge it in court. And I wouldn't recommend that anyone just casually do that. You got to be ready to actually challenge it in court and have good lawyers and all those things. But if we go one removed from that, I received a transaction from a regular old Ethereum address. Especially if you know who that person is, you know you're not transacting with a sanctioned person. If that person is Dawn, I know that Dawn is not a sanctioned person. She might have violated OFAC by receiving that transaction from a Tornado Cash address earlier in the chain. I don't need to know. I don't want to know anything about that. That's on her. Has nothing to do with me. My obligations are just, I'm not supposed to transact with a sanctioned person. And I know Dawn isn't a sanctioned person. So in theory, again, hire your own lawyer, especially if you have a large consequential transaction. But in theory, that transaction from Dawn doesn't violate sanctions. And so I'm fine. Now, this gets more complicated in the sense that banks or regulated entities like Coinbase or Kraken or whoever have internal compliance programs. And those internal compliance programs are extraordinarily risk averse because they interface daily with federal investigators and bank examiners who are very capable of shutting down their whole business if they don't do what they say. And so in that realm, where you're a giant corporation that's BSA regulated and needs to do things beyond just obey sanctions, you also need to comply with the Bank Secrecy Act. You need to know all your customers. You need to proactively take steps to stop money laundering in the financial system. They don't have clear standards. They have flexible rules that the bank examiners who come into their offices twice a year or whatever will make sure that they're following. And they may just voluntarily choose not to accept transactions because they're too risky, because the Bank Secrecy Act tells them they have to have a risk-calibrated anti-money laundering program. So just because there's no firm black letter legal obligation for, say, a centralized exchange to not take this transaction that's too hopped away from OFAC, doesn't mean that they won't just on their own decide, that's a little too risky for us. We're just not going to take that transaction, or we're going to immediately report that transaction. And getting into suspicious activity reports and things like that, I think it's a pretty safe bet that if you had, say, a Coinbase address and your Coinbase address got paid from a regular old Ethereum address that one transaction earlier had gotten a Tornado Cash transaction, Coinbase would probably look at that and say, well, I guess we should file a suspicious activity report for this transaction because it's so close to this sanctioned entity, right? That's going to be a judgment call on their part as part of their risk-calibrated anti-money laundering program, but it's worth considering if you're a customer of one of these exchanges, your transactions might get marked as suspicious simply by virtue of the person sending them to your custodial wallet provider has been one hop or two hop away from a sanctioned address.
You also mentioned the immutability of cryptocurrency contracts, and I'm wondering if that presents a specific defense to some of these regulations in a couple of ways. One is that if there were a regulation on the contract itself, not just the addresses, that said that, for example, this contract needs to automatically report transactions somehow, is there a defense along the lines of this contract has already been published and is immutable and we cannot retroactively, comply with this? And secondly, even specifically with respect to the current sanctions on Tornado Cash, if a contract has already been published that is set to pay out to a Tornado Cash address after a certain period of time, is there an argument that, this contract cannot be changed, after the fact, and so, it is going to interact with the sanctioned address. It is programmed to do so, and we can't change that now. So both of these ideas are related to, immutability as a defense.
So what I would say is, in general, immutability and these ideas strengthen our main claim here, which is that this is not how the statute is structured to enable policy. The statute is about people and entities. And the reason for that, the given reason in the statute and in the regulations, and even in the press releases from OFAC, is that sanctions are not a punishment. They are a tool to change behavior. That is the stated goal of OFAC's policy. We want to change behavior. They want to change the behavior that's led Iran down this path of being what certain people in OFAC believe means that they're an enemy state. We want to force them to liberalize their government, to become a democracy, any number of other things. And until they do that, we're going to sanction them. So if you're sanctioning a smart contract that is just software and can't change, there's no possibility that what you're doing is actually aimed at changing the behavior of the smart contract, because it's not going to happen. It's like waiting for you're commanding the tide not to come in. You're King Canute on the beach. It's an old law story, back to Anglo-Saxon common law, but it's just silly. And so if that's obviously not what they're doing, what are they doing? They're doing something else. They're using the same rules, but for a different policy purpose. In this case, to stop Americans from using certain tools, which is not the stated goal or policy or objective behind the sanctions laws. The stated goal is to change behavior. So yeah, when we point out how these things are immutable and behavior is not going to change on the part of the smart contract, we're self-evidently pointing out that they're not using these laws as they were intended to be used. Because obviously you're not going to change the robot's behavior. You're trying to change innocent Americans' behavior and telling them to stop using this contract, which is not what sanctions law is supposed to be about.
Okay, so this is the last question I have for you in this regard, unless I see other questions in chat. So you kind of addressed already the question of how the sanctions on Tornado Cash impact exchanges and centralized wallets like Coinbase. How does this impact Ethereum miners, or I guess validators? Are they subject to the same requirements? In other words, Coinbase has some jurisdiction on whether or not to include a transaction or to allow a transaction on their platform. For a validator, rejecting a transaction because it was recently involved in Tornado Cash or even directly involved is deviating from the protocol. So in some sense, they're not supposed to do that. So do you think that there is still jurisdiction over just individual miners or validators where it can be argued that they should not be allowed to include those transactions that are sanctioned?
Yes. So there's an important carve out from IEPA. IEPA is the statute, again, that empowers OFAC to sanction persons and to block Americans from transacting with those sanctioned persons. When the statute was being debated in Congress, in fact, it was being updated, and there was a debate over how to update it. The debate focused on, it was actually a very interesting trigger of the debate too, which I'll just briefly mention. It used to be the Trading with the Enemy Act. So it used to be a statute about actually when we're at war with a foreign power, the president has sort of much more and much less constrained power to stop people from aiding that enemy, right? But if we're talking about the modern world, and this was back in the 70s, but already people can see how it was going, is like wars aren't necessarily the only, like some things are like the war on drugs or the war on terror. Things will continue for long periods of time, and they'll be treated as an emergency that warrants these extreme powers. But, without some obvious clock on the matter, maybe we should limit the president's authority. So Congress said, you know what, we can't just let the president declare permanent war on something like terrorism and perpetually have the otherwise justified powers that they would have when there's actually an active invasion of a country or something going on. And so Congress said, all right, we're going to weaken the powers in the context of national emergencies that are short of an actual war, which the cyber emergency that we're dealing with North Korea is. And we're going to weaken them in some specific ways. Specifically, like Congress is going to have to every year vote to say, yeah, we're still in this emergency. The president can't just perpetually carry the emergency on into forever. But another big one was we need to make sure that these powers aren't unreasonably extended to block transactions in First Amendment protected activities. And so there was this congressman named Berman who said, I want these carve outs. I want IEPA to not apply if the transaction in question is specifically and exclusively about First Amendment protected activities like trading in information, art, news, magazines, these sorts of things. And a lot of the early cases were actually about like people trying to sell art from Cuba, maybe even subversive art, maybe selling art to Cuba that actually like would convince them to overthrow Castro, these sorts of things. And so the Berman amendments made it into IEPA. And the Berman amendments on this point specifically say that IEPA generally exempts from regulation the importation from any country or the exportation to any country of any information or informational materials, regardless of the medium, regardless of how they're transferred. It could be CD-ROMs, it could be, the internet. And so I say all this background because the question of a Ethereum miner or a Bitcoin miner in the context of sanctioned Bitcoin addresses is really this question of what are they doing when they interact with the blockchain and the blockchain has some sanctioned addresses on it? Are they actually transacting with a sanctioned person? In some cases, maybe, because in some cases, maybe it's a North Korean hacker who's using Ethereum to do ransomware attacks, and they are actually paying the miner to put the transaction in a block, right? But then we can ask, are they simply transacting in information materials? It's a validly signed digital, it's a validly signed Ethereum transaction. If they don't put it in the block, someone else is going to put it in the block. It's really just a broadcast of already final, transaction information. So arguably that is carved out of IEPA's jurisdiction because this is, yes, is a transaction, but it's a transaction just about information, just about broadcasting transactions or broadcasting blocks on the blockchain. And then it's an even harder question, I think, from the government standpoint to claim, or it's a even harder claim from the government standpoint to claim that even if the miner or validator isn't directly putting a transaction from a sanctioned person in their block, but are merely, in the case of Ethereum's proof of stake algorithm, attesting to the validity of someone else's block as part of Casper, or in the case of, say, even more simply in Bitcoin, by choosing to build on someone else's block, their proof of work, tacitly endorsing or transacting with a sanctioned person because they're attesting to a block that has a sanctioned address transaction in it, or building on top of a block that has a sanctioned transaction in it. At that point, it's hard to categorize that as anything but a transaction for information or informational materials. Because you're simply saying like, these blocks have been seen before by the world. They have. It's part of a peer-to-peer network. You can see them. I'm just saying that this block is at this order in the chain and I'm adding a new block to it, or I'm attesting to that block following the rules of the consensus mechanism. That activity, to me, is the exact kind of activity that the Berman amendments were meant to exempt from OFAC or IEPA liability as part of an effort to encourage free speech and the transactions in information and ensure that those things aren't unduly chilled by the presidential powers that are found in IEPA.
All right.
That's an untested. So if you're a miner or a validator, you may have to make that argument. And so you'll probably want a lawyer to make that argument because it's untested. This is just me reading the statute and applying the law to the facts. I can't say with authority that that's gonna win at the end of the day in court if it ever comes down to a court fight over it.
Right. So we did have several questions about how this impacts miners. I also saw a question in chat about sanctions against countries broadly and sanctions that prohibit any kind of transactions or specific types of transactions with all entities in certain countries. How do you apply those to cryptocurrency in terms of enforcement? Unlike a bank, which is clearly domiciled in a particular country, sometimes it's not evident which country controls a cryptocurrency address.
Yeah.
And particularly a smart contract is not necessarily domiciled, but even when it comes to addresses, how are broad sanctions on countries implemented with respect to cryptocurrency?
So OFAC is a strict liability statute. Generally speaking, you're just not supposed to transact with a sanctioned person. And if it turns out you did, even if you didn't really know you did, you can technically be held liable. It's worth noting that the criminal, and so that's extreme, liable for civil penalties. The criminal statutes, which would actually lead to potential jail time and really substantial monetary penalties, they do have a knowledge component. So you have to know and intend to transact with a foreign person. And so, I think the answer to your question is it's going to boil down, like, yes, it's a problem that by virtue of the nature of cryptocurrency networks, we have a tendency to transact with a lot more pseudonyms than we would have in the past. And it may be difficult to learn who is actually behind the pseudonym, right? And which country they're in, and whether they're a sanctioned person or in a country that's sanctioned, and therefore maybe they are also a sanctioned person themselves. As far as how much risk this creates for persons, it does create real risk, because there are those civil penalties that could, in theory, be levied against you, even if you didn't know. But it really becomes dangerous if you did know. So, like, I don't know what to tell you. I mean, if you have like a really good reason to know that this DAO that is paying you for software development is actually just 3 guys in Iran trying to build a chemical weapons plant and wanting to raise money from some sort of decentralized smart contract mechanism, you should definitely stop doing that, right? If you're a US person and subject to US sanctions laws. In the situation, it's hard to imagine. So that's an easy one, right? Just obviously don't do that. I guess I would need a specific fact pattern to get down at a harder question, which might be just something. I mean, honestly, it's sort of like the Tornado Cash thing. In the Tornado Cash context, North Korea used that address. They used the Tornado Cash tools to launder money. That's true. And you just want to use the Tornado Cash address for your own purposes. And at what point do you have some level of risk? And it seems like, whereas before this OFAC action, I would have said you don't have that much risk because you're not transacting with a foreign person. Turns out you did have a fair amount of legal risk, because OFAC has taken a really aggressive interpretation of its power here. So it's a big problem. And I think it is going to cause a fair amount of chilling to innovation in this space, because, the people who we want building these tools, the people who want to obey the laws and who want to make sure that we have liberal democracies and free and open societies, are the people more than often who are going to be subject to rules like OFAC sanctions and are going to, be potentially vulnerable to enforcement actions and things like that. And so maybe they'll just say, screw it, I guess I can't build my tool for enhancing human freedom on Ethereum or Bitcoin. I'll build it as a traditional business, even though that carries other limitations and risks, and maybe it won't work as well. And that's unfortunate then.
You mentioned DAOs, and I think this is specifically one of the edge cases I was thinking of with that question, which is that, when it comes to things like DAOs, how, you have a bunch of thorny issues when it comes to policy here, because first of all, a lot of these are in fact backed by incorporated entities, but many of them aren't, and they are not even, national. They are sort of international entities controlled by, persons around the world. How do you think of about, first of all, jurisdiction when it comes to DAOs. Which country has the authority to regulate this kind of international organization with maybe stakeholders around the world, not necessarily incorporated anywhere? And then expanding on that, could you reasonably apply a sanction to a DAO, which is not an entity legally speaking, not necessarily a person, or is maybe a huge collection of persons? Have we seen instances of DAOs being sanctioned, and how would you think about the jurisdiction relating to that?
So, it's funny, I was looking at some of my old writings about DAOs from like 2015, 2016, back when the concept was sort of still new. And, people back then were like, you can think of Bitcoin as a DAO. You can think of the entirety of Ethereum as a DAO, because it's this, collaborative action that's achieved without centralized control, mostly through the use of economic incentives and cryptography. Modern DAOs don't look like that. Like what we colloquially refer to as DAO today is basically, to me, just like a typical business that instead of having a board of directors that meets on Zoom and records its votes on a Google Doc, they vote on the blockchain using tokens to reflect their voting power, their voting shares. And to me, if the functionality of the DAO is entirely dependent on the efforts of the DAO members, and the DAO members decide what that functionality should be through voting, I have trouble arguing that that's not anything except just an ordinary corporation that happens to have some rather eccentric practices as far as how its members organize. And that means that if their stock, if the voting shares and profit shares are traded generally, it means there'll be a security under US securities laws. And if they sell to US persons, they'll have to register as the promoter or issuer of a security. Let me put it this way. In a DAO that really is just people doing something in the world rather than a protocol that's doing something in the world. Like, what if a DAO bought the property next door to me, right? And they dug a giant hole and they didn't put a fence around it, and a child fell into the hole? Like, someone's got to be responsible for that, right? And it doesn't matter if they're not US persons. An American was hurt. They fell into the hole. This is starting to sound like, what is that show? Is it, this is the show with the local government where the guy falls into the hole. Anyway, sorry, Parks and Rec, that's the show. Someone's got to be liable for the hole. And the fact that you decided not to form a corporation to dig the hole in an unsafe way doesn't matter. In fact, it makes it much worse for you, because under US law, the person who falls down the hole can sue the organization that dug the hole in an unsafe way. If it's a limited liability corporation, then the best they can get in a judgment for a negligence is the corporate treasury of the LLC. We can take that money in damages. If it wasn't an LLC, limited liability corporation, the common law in the US and in most nations will assume that it is, as default, a general partnership rather than an LLC, even if they never created a document that said we are a general partnership. That's the default rule. And in a general partnership, every partner is jointly and severally liable and personally liable for the activities of the whole. So person falls down the hole, I want to sue who dug the hole in an unsafe way and get damages. If I find just one token holder, and I can go to them and I can ask the judge and I can say, this guy should be held personally liable, not the corporate treasury, his own finances, for the acts of the group as a whole. And if we can't find anyone else who's a member of this group, he's on the hook for the entirety of it. That's good law in the US. And I'm not saying it's good. I'm not saying it's the right policy here, but that is how the law works in the US. So, I've given an extreme example. There are like real DAOs out there that are not just people voting to do things in the world, that are maybe people like collaboratively working together on software. And that is a protected activity if they're just publishing software. If they're also making money though in some way, it might not be protected. There's shades of gray here. So it's a fraught area, I guess is what I'd say.
So, Peter, is it your understanding that this, joint liability of the shareholders would apply even to purely protocol-based DAOs, where, if the DAO makes a decision, none of the shareholders necessarily voted on or endorsed that decision other than holding shares? Do you feel that if there was no incorporated entity, that the shareholders could still be liable for even completely automated decisions made by the DAO?
So it's a hard hypo, because like all they did was publish software, and then people use that software, and then someone's holding them liable for having published that software. In that case, if they're US persons, they might have legitimate First Amendment defenses from that litigation. If, on the other hand, they did more than publish software, like they went out in the world and they said, hey, you should bring your money to this Ethereum address that has this software, and when you do, you'll get this other asset, and I promise you, and even if they don't say I promise, or you'll be pleased to discover that this other asset will go up in value in the next 10 years or something like that. Then they've done more than publish software. They've made warranties and representations, arguing that the quote unquote protocol driven thing will perform in a certain way. And at that point, they might be liable for securities fraud or any number of other things. But in a situation where like there's a random number generator and a DAO is organized to finance the software development for coming up with better random numbers, which is a real problem in computer science. And then, somebody uses the random number generator and it wasn't random. And that can actually have pretty real consequences, because then maybe the encryption's not good that this person's trying to do with the random number, and maybe their trade secrets get released to, hackers. At that point, I don't think that these creators of this random number generator, even if they're organized as a DAO or if they're organized as a corporation, it doesn't matter. I don't think they can be held liable merely for that, right? Assuming that they disclaimed warranties and they never went out and promised a certain degree of randomness or something like that. It's when you do those extra things beyond just creating software that you start setting yourself up for some sort of liability, right? But, in answering this question, I'm realizing the fact of whether it's a DAO or not is kind of irrelevant. It's just whether you made promises to people, either as a formal entity like a corporation or as an individual who's a part of a DAO, and whether you can then be held liable for disappointment with regard to those promises. And in a lot of cases, the answer is probably yes. And the fact that you've organized this thing through a DAO isn't going to offer you very much protection. In fact, it may do the opposite, because again, if you form a limited liability corporation, you're shielded from personal liability. If you form a DAO and the court then says, well, because you didn't incorporate, the default is general partnership, now you are personally liable.
Right, thank you so much, Peter, for this excellent discussion. I think we're about out of time today, but I'll let Dawn make any concluding remarks or questions.
Yes, Peter. Yeah, thank you so much for this really fascinating lecture and all these great discussions. I think the students really have learned a lot. And we are at time now. So yes, yeah, thanks again, Peter.
It was a pleasure.
Yeah,
thank you for having me.
Thank you so much.